Let's get to the lawsuits. Let's deal with the big one. We'll start with Sidney Powell's dismissal on appeal in Georgia or Wisconsin. I think it was Wisconsin, right?
Georgia. So I believe they filed suit now in Michigan, Wisconsin, Georgia, and Arizona. I'm not certain about Michigan, but I've seen the suits from Wisconsin, Arizona, and Georgia, the Kraken suits. And what happened in Georgia is they initially got relief. They got a federal judge to grant them relief, and then they appealed it, which we talked about on Wednesday, the midweek stream. That didn't make sense because the likely outcome was going to be the Court of Appeals would say you can't appeal, and then they would have lost their time window and also, unnecessarily upset the district court.
And
so on Friday, the Court of Appeals came in and denied it, said yes and made a lot of comments to the effect of, what in the world are you doing? You had a judge sympathetic. You could have had a full hearing. You had an opportunity to present evidence. You blew all of that by appealing something they didn't say it, but they almost said was a frivolous appeal. There's just no grounds to get this appeal. You're undermining your own timeline. You're undermining your own remedies.
Let me just say, so everybody appreciates this also. They had gotten a temporary restraining order, which was an order from the court enjoining from the modification or the deletion or the altering of the voting machines for 10 days, temporary restraining order.
And the reason why the time frame on all this is tight is because the way these machines work, because there's an upcoming runoff, they often purge aspects of these machines in order so that there's no vestigial problems from the prior election. And so they're on the clock for that to happen. And that's why, and they knew they were on the clock, and that's why expediting the remedy was even more important in that context than just the ordinary presidential election deadlines. But frankly, they blew it all up by taking an appeal that went nowhere.
Oh, and I didn't understand what they were appealing. And I watched Recchieta's Law's overview of this. I didn't understand what they were appealing, because you get a temporary restraining order. It's a 10-day order, which you can, in theory, let me just get this super chat down, which you can, in theory, renew or, get another temporary restraining order afterwards to go for another 10 days or whatever. So I didn't know, and I still don't understand what they were appealing. Did they want a longer hold? Did they want more protective measures? So I didn't understand that. I didn't understand what they thought the Court of Appeal was going to do. And just so everybody appreciates the procedural aspect of this, is that there was a hearing date, an evidentiary hearing date scheduled during the 10-day temporary restraining order. So while they are being enjoined from modifying the machines, they were going to have a hearing. By virtue of appealing the decision, the judge can no longer have that hearing because it's appealing his original decision. And so they lose that hearing, and they might have another hearing, which would be after the safe harbor date. Which
Correct.
Might be too late.
And at some point, it's going to be running right up against the runoff when the machines have to be restarted for the runoff. So they blew a chance to present evidence and undermined the appearance of what they were doing in front of both the district court and Court of Appeals. So I don't understand it tactically. Almost no one who was watching it understood it tactically. There were people that were critical who said, look, this is what someone who doesn't have evidence would do. Run out the clock. So they never given the chance to present evidence and then say, you know what, I really had the evidence. The courts just wouldn't let me show it. That's where the critics are. I'm not there. I think these are tactical errors of people who don't do a lot of complex federal civil litigation. They just because you're experienced in one area of law doesn't mean you're skilled in another area of law. Well, so, federal criminal procedure is very different from federal civil procedure, and state defamation cases are not the same as election contest or civil rights cases. So, I've seen some criticism. Well, why don't other people volunteer to help out? They received all this information. They chose their path. So they're not doing any of this pro bono. So they're raising, both Linwood and Sidney Powell raising money. Linwood apparently is receiving large sums of money related to this. So the idea that this is because they're patriots simply working hard and no one will help them and they have to do it all by themselves, that's all nonsense. That's not true. So whatever you think their motivations are, their tactics are not helping at this point. And so far the Kraken suits are like, oh, for whatever. I mean, they're not getting anything. And so that's what happened in Georgia. And Wisconsin, something similar peculiar happened. So one, they sued in the Eastern District of Wisconsin. Don't know why. Not a lot of good judges there. In my view, well, geez, I better be careful what I say. I'm in the East District of Wisconsin a lot. For this kind of case, that's what I'll say. It might have been a tough draw. So I'll find some diplomatic language to use, some more Viva language to use.
Canadian language.
Yeah, exactly. Yeah, Canadian. Canadian approach. Everybody's okay. Some people are just not as good as others, or not as whatever. So but they sued there. There were a bunch of mistakes made in the original filings. The judge took pot shots at them. I thought some of those pot shots were unfair. Some of them were deserved, but some of them were unfair. Then they file their request for a hearing for their big injunction, and they request there be no hearing. They request everything be done on the pleadings, and that the judge makes the point. She said, I don't think I've ever had someone ask for a preliminary injunction of this, particularly of this kind, but of almost anyone, and say they don't want a hearing to present evidence. But that's what happened. So, again, if the Kraken is just continuously mysterious, and every time they're given a chance to have a hearing, they're either deliberately withdrawing it themselves or blowing it up. And in Arizona, it looks like they'll lose the chance at an evidentiary hearing, and a motion to dismiss will handle. So increasingly, I have less and less sympathy for these cases. They did severe damage to the impression of election fraud in the court in terms of politicians. Court of public opinion, it's all great. You're going to have tons of people that will believe everything that Sidney Powell or Lynn Wood say, no matter what, because it's what they want to hear, and it confirms it's confirmation bias times to the nth degree. It's why large parts of the left will always believe Russiagate. So regardless of evidence, regardless of confirmation or anything else. So I understand where that's coming from, but that didn't help the president get actual remedy when he had a shot at actual remedy. It was a long shot, but it was still a shot, and it still is a shot. It's just becoming more and more of a long shot because the perception of these cases is being shaped by the Kraken cases. And they're easy for the left to take pot shots at. They're easy for the media to take pot shots at. They're easy for the courts to take pot shots at, because they did not have the evidentiary substantiation that Sidney Powell led the world to believe was present. And they're doing things that are undermining the opportunity to present evidence or discover evidence repeatedly in ways that, again, the people who think this is just a big grift for either fame or fortune are seeing their predictions come true and not their supporters' predictions come true. So,
and I got to be, I was going to say, in fairness to you, Robert, I mean, Recchietta was diplomatic as well in his assessment, but lawyers and analysts don't understand the move. I didn't understand the move from the beginning, but I didn't understand what they were appealing from the beginning, and maybe there's some underlying strategy. Maybe it's a question of publicity, whatever. But it seems it's pretty universal, even from people who want to find the best in it. They didn't understand why. It's running the clock now in a way that's not helpful. We'll see what happens.
Yeah.
But
I think short answer is Kraken cases don't look like they have a better argument against dismissal for standing because they brought electors. But it looks to me like they've sued exclusively in federal court. And I think that's tough given where federal courts have been of late on these issues, particularly in the post-election environment, but historically as well. So my guess as to outcome is they are likely just to get dismissed everywhere. They may get an evidentiary hearing nowhere. And they'll run it up the flagpole, but it'll likely all get rejected everywhere, and they won't likely achieve or accomplish much of anything, frankly, from a legal perspective. Maybe, again, the goal was something in the court of public opinion or something else. But also there's going to be a lot of people who will not look at either Lynn Wood or Sidney Powell the same after this. They'll see them as people who overpromise and underdeliver because, frankly, that's what's happened so far.
Well, so someone, actually civil servants, I didn't bring up this one, but wear matte glasses. I only have one pair of glasses. I can't have things because with kids things don't last. But civil servant actually asked before, so the Dominion suits are up or they're over, done for. But I do think I heard news coming out of Michigan that they are getting a full audit on 23 Dominion voting machines or multiple Dominion voting machines.
Yeah, so this is a good transition into Dominion. And there's several different things. There's a bunch of different suits concerning Dominion. There's some election contests concerning Dominion. There's some federal civil rights claims filed by other people concerning Dominion. There's state court cases concerning Dominion that are independent of the Powell cases and the Lynn Wood cases that I don't think will end up being able to achieve much. Now with Dominion, there's just been a lot of misinformation out there. or information that, put it this way, evidence does not support or substantiate in a way that would be admissible in a court of law in the United States. So, for example, there's suggestions that Dominion and Smartmatic are one and the same. They're not. Dominion had a deal to purchase a subsidiary of Smartmatic almost 10 years ago, and that ended up not going through. They ended up separately buying it, and Smartmatic has no role with Dominion. It's just Dominion was not created in Venezuela or Cuba. None of that is simply accurate. It's currently not owned by any foreigner. Its CEO is Canadian, and apparently that's become a bad thing. But put that whatever you want. But its key owners is Staple Street Capital, which is all people that used to work with the Carlyle Group or Cerebras. And that's American interest. That's not foreign interest. Now, you might want to people might want to look into Carlyle Group and Cerebras and look up, Dan Quayle's connection and look up the Bush family connection and look up. I mean, basically, you don't get more institutional Washington and Wall Street than you get the Carlyle Group and Cerebras. So there's some legit, but that makes me even more suspicious as that this was a disinformation campaign, maybe being relayed honestly or in the dark by Lynn Wood and Sidney Powell. But this is a Wall Street, Washington based company, effectively. That's where all their roots are. This is not somebody tied to China or anything else. And it appears they got a UBS division. UBS has like 100 divisions, but they got UBS, a huge, huge Swiss bank. They got their Chinese branch confused with their New York branch, so they thought money was coming from China that was really coming from the New York branch. There's been a lot of misinformation out there about Dominion. And again, I'm someone who's opposed to computers being involved at all in our elections, aside from a backup mechanism, and think we should go to all paper ballots left and right in toto. But and not a fan of Dominion, period, or these other companies. But a lot of this is secretly China, and the ballots are coming from China and Mexico. I don't even know what that's supposed to mean. I mean, those were the ballots that ended up being counted. I mean, otherwise, who cares? So, I mean, there's a lot of allegations that appear to be disinformation that are just being repeated by Lynn Wood or Sidney Powell, no matter how ludicrous or the allegation or ridiculous, frankly, the source. And so it's not helpful because it makes it easy for people to take pot shots and to caricature and to straw man the Trump arguments, which are not rooted and founded in that. So that's a history sort of Dominion. There are issues with Dominion, but not the ones that are being highlighted. The biggest problem, like there was today, someone, I believe, misinterpreted information from a county in Georgia that had according to their local election officials during the manual recount, they found that they had made a mistake, a tabulation error that was not software or computer based, of about 40 or so votes. About 37 went to Trump, 42 taken off of Biden. The others were not properly counted. It appears, one of the potential problems is people running through ballots too many times. That's the reason why you need observers. That's one of the reasons for the issue about the Atlanta video, which exploded this week in Fulton County. But apparently someone misunderstood that to mean that was evidence of Dominion software. And like the Georgia Star News and some publications that are more secondary publications didn't quite vet it correctly. So what is, you get people running off with a Dominion story that is now going to be easy for the media and the critics to shoot down, when in fact there was a legitimate issue about the real problem was people running through ballots, having no mechanism in place to make. They should have a mechanism in place that if it has a certain serial number, and all these ballots do, they have a certain barcode on them, at least, that they don't get counted twice. That should be built into the system. Somehow, apparently, it's not. So so that was really the issue, not this other issue. And in general, the big problem. So they're going to get to look at in Michigan, in Antrim County is where there was a mistake made. According to the people in Antrim County, the election officials, it was human error, nothing to do with the machines. But the court was willing to have them look at the machines. And I found this to be all true in a lot of places. They're happy to have you go the machine route because they know you're not going to get anywhere. While everybody's spending their time over there, they're not looking at what was a very big development in the Arizona case that managed to get completely quashed from public media coverage, which was the claim that many of us were making in the Trump camp that signature matches didn't happen, and an objective review would show that there's a much higher rate that should have been rejected than was confirmed by the Democrats' own expert in an Arizona election contest.
Okay, so that's a good segue actually as to now what the status is in the various states. And there was another thing I don't know where it was now, where apparently they counted the votes and it was supposed to be 100% for Trump and 100% for Biden, but apparently the recount ended up being 113% for Biden and 87 for Trump because of fractional counting or something along those lines. So
and there's people that are making an allegation and it's just not backed up ultimately. I mean, here's an important part. All the algorithmic manipulation, all the software manipulation allegations, all of that stuff, aside from them getting a whole bunch of basic facts wrong, was effectively refuted in Georgia when they did a hand recount, and it's been refuted in parts of Wisconsin when they did a hand recount. So that's why they were happy to do that. They were never worried about from the moment I was down in Georgia, they were never scared about the machines being a problem at all. So they thought they wanted that to be the focal point. They wanted the hand recount to be the focal point and not the signature match, and not a check of registration rules and other issues, and not a check on whether certain people voted who legally could not. That they wanted to hide from. The other they wanted everybody to run to, and Sidney Powell and Lynn Wood have greatly helped the critics of Trump by having everybody rush to something that is highly unlikely to ever be proven. And while they're not, because remember, folks, when you're looking at one thing, you're not looking at something else. And so it's one of the oldest games in the book. It's why disinformation campaigns are waged. And so there's been all these allegations of fractional voting. Well, they did the hand recount, and including in Republican counties, in Republican areas in Georgia, where Republican monitors could observe, the hand recount showed no algorithmic manipulation or software problem, period. So that's the reason why that's always been a red herring. And the fact that people keep wanting to scream, look at the red herring, please look at the red herring, is not going to be helpful to getting any actionable remedy now, and is going to make it easy for your position about legitimate issues to be caricatured. But so to the election contest. Election contest was filed and adjudicated at the trial court level in Nevada this week. There's many election contests in Arizona. One of the election contests in Arizona was adjudicated at the trial court level this week. It appears that the Wood-Powell Kraken suits are bringing election contest in federal court. I don't think that will go anywhere. There is an election contest, multiple election contests, including by the Trump campaign, now filed in Georgia. I believe one was filed in Pennsylvania, but I have not received an update on that. I know the Trump campaign, I think, just missed it, didn't get one filed in Pennsylvania. They appear to be putting their hats in a different ring on that. And in Wisconsin, you only have a remedy to a recount, and then you get to challenge the recount. They filed an original petition with the Wisconsin Supreme Court. I'll get to the update there. And in Michigan, they have some cases pending. So the election contest in Arizona, they went in and requested a remedy that I thought was very helpful, which was we want to be able to look at whether a signature match was actually done. They also looked at duplicate ballots and found issues there too. But they wanted to look at how many was the signature match really done? When Republicans had their expert, Democrats had theirs. I'm going to cite the Democrats expert because he actually had a motivation to keep the number down. But the Republican expert came up, was more liberal. This is your classic Republican expert. He comes up with more excuses to say something's a match that's not. But put that aside, the Republican expert says at least 6% are not valid. The Democrat expert comes in and says 11% are not valid. And to give people an idea, over 80% of the ballots were mail-in Arizona. That means, and this was the judge's definition of a random sample that's statistically significant from an evidentiary perspective. The judge chose this, not the parties, the judge. So you project it out, and what that means is almost 9% of all mail-in ballots in Arizona are invalid, and that is more than 30 times the margin of victory in Arizona. Now, I'll get to how the court, dodged and evaded the issue, but that was a huge finding because Arizona is much more accustomed to mail-in voting and doing signature matches than Georgia, than Pennsylvania, than Michigan, than Nevada, and at this scale and scope. So you play it out. In fact, and this is not, I'm not making this up now. I said it last week. I said Arizona will have the lowest rate of signature match problems because of this history. So if you have an 11% problem, according to the Democrats' own expert, of signatures not matching, you're going to have at least that in all these other states, and that's way more than the margin of victory. And the legal standard is supposed to be If somebody cast their ballot illegally or their ballot was counted when it should not have been, then that is the standard. Not whether they deliberately did it, not whether or not it's fraud, not whether or not it's a conspiracy, not whether or not it's a forgery. To be frank, all of this nonsense about Dominion and the rest has encouraged and incentivized this focus on fraud that is allowing courts to escape the regular legal standards easier. It's part of the reason why I've been as critical as I've been. It's not because I feel like it. Otherwise, who cares? It's because it's badly impacting these other cases. This pursuit of bad arguments or bad evidence or bad theories. But the Arizona court decided to change it. Now, Nevada, similar. They showed a whole bunch of people who voted who were illegally registered.
Wait, before you get there. So the Arizona court now says, or the Democrat expert in the Arizona contest says upwards of 10, 11%, not matching or not checked.
Didn't match.
Okay. So what was the sample? Do you know how many ballots they were sampling? Was it 200 or was it thousands?
I think it was around there, because originally he was talking about 100, then he may have gone up to 200.
Okay.
I don't know what the final one was, but it was the judge's determination. It was randomly picked, and the judge said this would be statistically significant for evidence purposes.
Okay, and now, so the judge comes to this determination. What's the state now of that contest? That's not a ruling.
What the judge says is suddenly the standard is no longer, are there more illegal votes than not? Like, for example, if you showed up late to the poll and you were not in line by closing time, you don't get to vote. It doesn't matter that you had no fraudulent intent. It doesn't matter that you had a lawful right to vote. You didn't go through the lawful process to have your vote legally count. The same is true for the absentee balloting process, mail-in balloting. If your signature doesn't match, you as a voter take the risk that your vote won't count. You can deliver it in person. You can ask, make sure it was checked and confirmed and matched. You can vote in person. So you have these other remedies available to you. It's on you as a voter. Just like, it may not be your own fault that you show up late on election night and you don't get in line in time, but it doesn't matter. Your vote doesn't get to count. You have to vote lawfully by the legal procedures. So that's the legal standard. Were there any votes that counted that did not meet the lawful standard for a lawfully cast vote? And then second, is it more than the margin of victory? Well, the judge decides to change it. Now, here's my guess. I told people that all these judges are going to buy the judges sit there and watch CNN, MSNBC, and that nonsense. And they're going to listen to people like the Georgia Secretary of State and Gabriel Sterling, that never Trump hack in a key position of power down there, who are saying, oh, don't worry, the signatures do match. And it's been checked double and triple and all this stuff. And I told people, one, that's going to be a lie. Because just human error would have a higher rejection rate than what this is. So that, in fact, they didn't really do the signature match. But second, but the judges will believe it, and so they'll allow a signature match check to be done if you can get it in there and focus on it. And I'm sure the judge was shocked to see that it was such a high rate. And so he decided to change the legal standard. He said, no, you know what? It doesn't matter whether the signature doesn't match. You have to prove it's a forgery. Now, of course, what every judge does know is that for forgery, you have to have 100 samples or specimens on average. So you could never prove forgery from a absentee ballot signature. Never. You can just prove it didn't match. You don't have enough specimens to compare the person's signature to be able to, within an evidentiary expert handwriting perspective, call it forgery. That's where the judge was being deliberately dishonest. And that's what happened.
Okay, but now the judge says it's not forgery, you can't prove it. So what happens with that contest?
So he denies the contest on the grounds you have to prove forgery or fraud. And now it goes up to appeal. But that was the other thing I was telling people: establish the factual record. If you get up to this, ultimately it's going to be Supreme Court and Congress that ultimately matters. Maybe the state legislatures will do something, but that's kind of always a long shot. They haven't had courage. I mean, they've been rolled throughout all this COVID thing. The idea that they're going to suddenly get courage is low. Ultimately, Congress and the Supreme Court decide anyway. Particularly Congress is the ultimate arbiter here. Their decision will always be final. But to give them the ammunition, to give them the political cover to take political action that they should take, establish a factual record that you're right. And that's where my position all the way through was: show the signatures don't match. That gives you more illegal votes than votes in every single one of these key swing states, enough to swing the electoral college majority. And then the Supreme Court can just say, look, these votes are in doubt. They did by the legal method. You knew how you had to lawfully cast it. and you didn't lawfully cast it. And so the remedy is it goes to Congress to vote by state delegation. And so the utility is that they established the factual record there in the Arizona case. They also established a good factual record in the Nevada case. The court did something similar there. He excluded evidence on a. Here's the other thing. They're exposing how they never intended these election contests to work for people like Trump. They're accelerating the timetable of evidentiary presentation. They're coming up with, they're shifting evidentiary standards, shifting legal standards, shifting access to evidence, because they're saying they give these people 3 or 4 days and they say, well, okay, you have a list of 50,000 or so people that you say you have proof didn't vote by various expert evidence. I mean, they had books and books and books of material in the Nevada election contest case. But you didn't depose them. You didn't. You're now being obligated to prove a massive criminal conspiracy in about 2 weeks, in some days 3 or 4 days. And if you can't prove a massive criminal conspiracy, you're out. Which is a joke. You could never prove that. Now it's showing what we need for election contest reform. We need, really, we should move inauguration date out. We should allow at least 3 to 4 months of this kind of independent information discovery, because it's showing how it's being mishandled, tells us where we need to improve the probabilities of success. Change some of the evidentiary standards overtly so that they shift. My view is if you show X number of ballots are invalid based on, say, Matt Brainerd's great work, then it should be on their burden, the other side's burden, to show that the election was actually clean and legit and that those voters were legit. So they developed a very good factual record, because my argument strategically to people had been establish a good factual record that shows there are more illegal votes than the margin of victory, because then you just run that up to the Supremes in Congress and they can either choose to act or not act, but then you have the evidentiary record you need. And that they did well in Nevada, and the election contest did well in Arizona. There's other Arizona election contests pending. They did it pretty well in Wisconsin, really too. Now, in Wisconsin, Trump campaign files an original petition, and some other folks filed an original petition for the Wisconsin Supreme Court. And this is classic with judges in the Trump era. And that's a Republican majority Supreme Court in Wisconsin. One of the Wisconsin Republicans is like, golly gee, I don't want to get involved. This looks so bad. Let's just send it down to the lower court and see how it goes. So they're weak. Whereas every Democrat has aligned against Trump, just as they would have aligned in favor of Hillary Clinton or Joe Biden. Every Republican judge does not. And so the Republican judges went AWOL, and so that should have been fast-tracked. Instead, it's being slow-tracked. Now, they still have the same evidentiary issues, and they still have the same opportunity to present that record and a chance to get up to the U.S. Supremes. So they're doing enough, and in Georgia, they've challenged it on multiple grounds. Very good election contest filed by the Trump campaign and joined by David Schaefer, who's done a great job. The Georgia Republican Party has done well. It's been the Republican National Committee that's been occasionally AWOL, and the institutional elected Republicans who haven't always come to Trump's defense in Georgia. But the Georgia Republican Party, David Schaefer, has done great work. So they brought a very good election contest. They laid out, look at all the voters that are illegally registered that voted. Look at the dead people who voted. Look at the duplicate votes, people who voted more than once. That always reminds me of Trump's joke. He's like, people say don't vote more than once. So, well, why not? If you're voting for me, he was just talking about how the system really works. And he goes, and people always say, just go out and vote, even if you're going to vote for the other guy. I'm not telling you that. If you're not going to vote for me, stay home. You don't need to go out and vote. So, he's just honest about that kind of thing. But they went through all the different illegal votes, including, of course, that there's no real signature match. They're requesting that. Multiple other election contests have been filed, including by one person who's a member of our board has filed an election contest. The locals, the Viva barneslaw.locals.com board.
You sent it. I haven't read it yet. This week, I was trying to do some non-election stuff this week, including PewDiePie's copyright troll with YouTube. I don't know why people are saying Viva as though I missed something. I think people want to know what you think of pardoning Assange and Snowden, but we've talked about that, but we'll get to that. The first thing I need to get to, because I missed it, and Cleopatra reminded me. Perhaps you can answer the college student's question about COVID force majeure. Do you know, does anyone know what?
I assume she's referring to like all the insurance disputes. So you have governments closing people down, and the excuse of insurance companies to not pay. You had all these people who took out insurance for something just like this, like a natural disaster, even things like that. but they're saying that this is all outside of that. That this was a pure act of God, and so consequently, they don't have to pay anybody. Now, there's a lot of lawsuits pending. It depends on the quality of the insurance contract. Some of those contracts you can't sue on. But those cases, I assume that's what it's referencing. In terms of all of this talk, I guess it is probably a useful trend. So the election contests are moving forward. There's going to be hearings in Georgia this week. In addition, in Pennsylvania, the case they took up to the U.S. Supreme Court, Justice Alito scheduled it for briefings to be done by Tuesday. And I think, by the way, the federal court in Wisconsin made the point that I think Alito was thinking about. A lot of people were reading into the tea leaves about the nature of why Alito had a date that was potentially after the safe harbor date for the electoral college. None of that is really, I mean, until Congress certifies, I mean, any court can act up until January 6th, at least. Because on January 5th, they could issue an order and say, you, Congress, cannot certify, or you, Vice President, that's who actually does it to Congress, you cannot certify these electors from this state. Right? So they have until January 5th. At a minimum, what the Wisconsin judge noted, that she had at least until December 14th. So she was like, look, the Electoral College doesn't even meet till the 14th. So if the goal is the Electoral College, we can wait. I can issue it a day before then. Now, that judge may have other motivations of making it hard to appeal in a quick time frame, but that would be some speculation of that effect. But it's all been made, facilitated by some of the tactical choices taken there. But so Alito can definitely get involved. This will be a big Q. Will he get involved? There was a very good brief filed. I want to say it's the Landmark Legal Institute. I think I pinned it up on our locals board so people can read it. Right? Excellent brief explaining why this is a federal constitutional issue, number one. Number two, explaining the political reasons, persuasive reasons why Alito should take it. And three, note what they go out of their way to distance themselves from. They make it clear, like, we're not alleging massive conspiracy. We're not alleging massive. In other words, they're telling, they are recognizing that courts are never going to issue the kind of remedy for the kind of things that Wood and Powell are talking about. So they wisely separate themselves from them and say, this is just about making sure we have elections that operate according to the law. Because if our legal remedy is always going to be you can't sue beforehand because you haven't suffered injury yet, and you can't sue afterwards because the injury's already occurred, and hey, we can't throw out votes because they've already voted. But before the election, we told you they may never vote that way, so we don't have to worry about it. This is not the way to run an election. And they did a good job pitching that to Alito. We'll see if he takes action.
Okay, I just brought the question out because a number of people had asked, what is the significance of the date that Alito picked? He said that people were making...
So originally he said December 9th to finish briefing, and the safe harbor date is December 8th. But the safe harbor date is solely a creation of federal statute. It's not from the Constitution.
I need you to explain to us, because I think I've forgotten. What is the meaning of the safe harbor date? Okay,
so after 1876, about 11 years later, Congress got together, decided, let's set up rules so that if 1876 reoccurs, this is how we'll be governed. At the time and since, the argument has been that is an unconstitutional law because the Constitution provides how the process is supposed to work. But the electoral, I think it's Electoral Contest Act, if I recall right, it's the 1887 law, Title III, I believe, is where it's located within. Of the United States Code, and basically it provided for all these rules. So that federal law says we're going to take whoever the governor certifies as electors. That federal law sets the date for when the Electoral College meets. That federal law says that if you have a contest within your state to determine who won the election, your electors will be recognized as winning as long as you decide that election contest at least 6 days before the Electoral College meets. The Electoral College meets on December 14th, so the safe harbor date is December 8th. The reason why that has had elevated significance is because of Bush v. Gore. But frankly, that part of Bush v. Gore was always bogus. So Bush v. Gore, they say, look, the way you're doing this recount is nonsense. It violates constitutional principles. It's a usurpation of legislative roles. It's a dilution of lawfully cast votes. All of that was based on good legal reasoning. But the question was, what was the remedy? why not just order a recount that does comply with equal protection, as Justice Breyer argued? By the way, all the Democrats take a different position on the Supreme Court back then than they're arguing now. Back then, they all argued the Electoral College deadline is not a binding deadline. You don't have to worry about that. All of that, Ginsburg and the rest of them. I agreed with them, though. Where the biggest area I disagreed on the Bush case is they said, there's a safe harbor date and the legislature is entitled to take advantage of that safe harbor date. So we're not going to allow you to continue the recount because it would run afoul of the safe harbor date. That was never a persuasive argument. It was solely so that they could make sure Bush won. The idea that those 5 justices were just following their conscience. It's not a coincidence that it was the 5 Republicans. So so that part of their ruling was always bogus, and Breyer kind of exposed them. Breyer was like, yeah, I agree. We need to have equal protection standards. We shouldn't have voter dilution, and this needs to be managed better. But there's no requirement that we meet some December 8th or 14th date, and there isn't. And so the great legal work being done by the Thomas More Society, the Amistad Project of that, the former Attorney General of Kansas, for those people who think I'm just critical of other lawyers, does great work, has been doing great work. He pointed out from the get-go, and he, by the way, has a nice election theory. They're connecting what Facebook and Zuckerberg was doing to these drop boxes and circumvention of signature and other rules related to absentee balloting. Apparently, he gave a lot of money to a bunch of election offices to do exactly that. And his point is that's not the legislature dictating the rules of the election. That's a private billionaire with the aid of local governments doing it in violation of the Electors Clause. So he's brought a nice, unique, creative case in that regard. But so that's why when Alito picked that date, I didn't think it meant anything. But all of a sudden, a whole bunch of people were like, oh, this means Alito's just going to dismiss it. Alito doesn't care. He's making it impossible to give a remedy. I don't think Alito ever was under the misimpression of what the Bush v. Gore case was binding in quite that way. But just to address that today, he moved it up a day. He's like, okay, fine. Everybody issue your briefs by Tuesday so I can issue my ruling if I want before the deadline. What's interesting here is typically they refer those to the whole court. He's not doing that. Alito was the one guy who might be willing to take action solo, because he's clearly agitated by how Pennsylvania has smacked him around. And that's why that's a great brief. The brief is written right to appeal to Alito, saying this Pennsylvania court is making a joke out of elections and making a joke out of you, Justice Alito, in the U.S. Supreme Court. That's what got the U.S. Supreme Court's attention in part in the 2000 in Bush v. Gore. So that will be an interesting case to watch. Now, am I overly optimistic? Is it still uphill? It's still uphill, because the U.S. Supreme Court, none of the courts have shown a real willingness to step into the breach to defend Trump. But this will be a big cue. Does he step up or not? I hope he does, but it's a long shot.